So, can we start with the session now?
Just give me 2 minutes.
Okay, sir.
Yes, we may start now.
Okay, sir. So, Namaste and good evening to all. Welcome to today's session organized by Think India Assam as part of its CLAT mentorship program, Guru Samarth. Think India is a national level organization that binds together students with a nationalistic strength from India's various top institutes of India, including IITs and NLUs, in order to harness their collective potentials and work towards national reconstruction. As a pan India organization, we strive to bring together the best talents and minds of the country and develop into them a solution oriented thinking process, thereby inspiring a young India to serve the society. Guru Samarth is a project taken up by Think India Assam to provide free CLAT mentorship for aspirants who seek guidance and help from the best minds from CLAT mentorship industry but are unable to attend their classes due to various reasons. Project Guru Samarth aims to bring the best faculty from CLAT mentorship industry within the reach of aspirants who lack the means and access to reach them, and thus making law a more democratic and accessible discipline within the society. Our fourth session today is based on legal aptitude for CLAT 2022, and we have with us Shri Anurag Shushan sir. Sir is a law graduate from Banaras Hindu University and has been mentoring students for CLAT and law entrance exams. Apart from this, sir has also been involved in legal manager in Tata AIG Generation Insurance Limited, and at present, he is working as a data protection and privacy lawyer. Without further ado, I would like to welcome Anurag sir. Sir, over to you.
Yeah, thank you so much, Samriddhi, and thank you so much, Think India, for especially for organizing such a initiative and inviting me to this, for making me a part of this. And I'm very glad to be a part of this initiative, Guru Samarth. So, in the last session, last Sunday, we looked into the brief knowledge or the basic knowledge about the law of contracts, and we also touched upon the essentials or the introduction to law of torts. Today, we shall discuss in brief and the basic elements, the basic types of law of torts today, and we shall try to cover the basic elements required for you to crack the law entrance examinations as far as the law of torts is concerned. So I shall share my screen here and then we shall start. So just give me a minute. So yeah, can somebody just confirm me whether my screen is visible, my presentation
Yeah,
is
sir,
visible?
it's visible.
Okay, fine. Thank you. So yes, we are starting with law of torts, and in the last class I've already mentioned about the essentials of a tort. So there are two legal maxims: injuria sine damno and damnum sine injuria. As we discussed last in the last session, basically law of torts deals with the acts that are twisted. Torts actually comes from the word tortum, which means twisted, and it basically depends upon or is based upon the general principle of ubi jus ibi remedium, which means for every wrongful injury there must be some compensation. So this is basically what the law of torts deals with. For this, law of torts actually applies two legal maxims to itself. One is injuria sine damno, which means legal injury without actual damage, and the second one is damnum sine injuria, which means damage without legal injury. So what are these two maxims? What does it mean? So injuria sine damno basically means that a person has suffered certain legal injury. Legal injury means the violation of certain rights given to the person by the law, or certain loss suffered as far as the legal obligations or the legal rights of the person are concerned, but without having an actual damage in the sense of monetary damage, or let's say a loss in the business or so. So in the last class we gave an example of two schools or two street shops opening in opposite of each other. So the first business will obviously suffer loss because of the second business in the same domain, exactly same domain, opening in just front of it. But that will not actually hamper any legal rights of the first business. It will just actually put on a damage to the business itself in sense of monetary earnings and all. But obviously it will not impart any legal injury. So in that case, that's not the case of injuria sine damno, but rather damnum sine injuria, which says that there can be a damage, but there will not be an actual damage in sense of legal injury. So when injuria sine damno is there, law of torts apply. Whereas if it is a case of damnum sine injuria, it doesn't apply. So there are certain general defenses which we talked about. Voluntary non-fit injuria, which means that the person has voluntarily taken that risk of injury. In that case, if you have voluntarily taken up that risk, that's a general defense. The law of torts won't apply. Plaintiff himself or herself is a wrongdoer. So if in an act where a case of tort had arisen, but the plaintiff himself or herself is not with the clean hands, is himself or herself a wrongdoer, in that case also this defense applies. Then the next one is inevitable accident. So by the term inevitable, we clearly understand that the accident was in any course of action with due care was not able to be uh, like was not in a we were not in a position to just evade that accident, and it was inevitable to happen. So if something is inevitable, you can't be considered responsible for it. So that's why it is also a general defense here. Then again, the same thing, the same logic applies to an act of God, where there is an event which is not in your control. You cannot control it, like some natural calamity. It's an act of God, so you cannot be considered responsible for that loss or that damage. Again, in private defense, you can take the defense of saying that I was having a threat or I was under a threat, and hence I did this particular act, which can be seen prima facie as a tortum act, but is actually a private defense and hence a general defense and not a tort. Then again, if something is done by mistake, so if it's a mistake, nobody is at fault. The term itself means that nobody is at fault. So again, it's a general defense. The next defense is of necessity. If something is very necessary, if a house is on fire and you have to trespass on somebody's land and take water from there to just uh, take off that fire, it's a case of necessity. So there this defense can be taken. Again, in the end, statutory authority, an act done by a statutory authority is also general defense. So like municipal corporation is digging the roads in front of your house, you cannot call it or you cannot claim it under law of torts. It will be a defense because it is an act that is approved by the statutory authority. So now we have we have seen all these things in the last class. So now we will take it forward from here in this today's class, and we'll talk about some of the important torts, act of torts today. So the first one that we're going to talk about is the act of nuisance. So nuisance, in a very simple term, means unreasonable interference with a person's right over his property or land. So if a person is enjoying his rights provided to him under the laws or any other provision where he is entitled to a particular enjoyment of his land or property, and somebody is unreasonably interfering, what does the term unreasonable here means? That there is no justification for that interference. Like if somebody is putting fire on all the leaves and goods in his own land, on his own land, and this is an everyday routine, and that causes smoke around, and the nearby neighbors are getting disturbed because of it, because that smoke flows into their houses and all, and this is an everyday routine. So like for certain purpose, if there is certain purpose for that on certain days, then it can be considered reasonable interference. But if it is happening every day and it is causing a lot of problems, obviously it is not reasonable. In that case, it will be considered a nuisance. So we can understand from the fact that certain unreasonable interferences can be caused to a public in general, the public in general, and as well as to certain individuals specifically. Based on this, we have two types of nuisances. First one is public nuisance, which comes under the IPC, Indian Penal Code, because obviously if something is against the society in general, public in general, and that is wrong without any justification, that is considered an offense. Basically, law of torts is a civil suit. That means we have to deal with only those acts which are against an individual, but not the public or society in general. So private nuisance is covered under law of torts. So as far as nuisance is concerned, so yes, we can say that there are three requirements, or we have to test the act on three grounds. First one is obviously the unreasonable interference, whether that interference or that act is unreasonable or not. The second one is whether it has interfered with the other person's right over his property or not, and whether that interference has caused any damage or not. So as we have already learned, that damage here doesn't mean a real actual damage. Rather, a legal injury is considered for the sake of law of torts to be applied. So it should be an injuria sine damno. So unreasonable interference, there is an interference to the rights of a person over his property, and there is a damage. Then nuisance or the act of nuisance is said to be taken place. And if it is against an individual, then it's a private nuisance covered under law of torts. So now moving forward to the second act of tort, that is negligence. Negligence in its simpler terms basically means breach of care. So every person has a duty, even if it's not written anywhere or even if it's not declared anywhere, that you hold certain duties towards certain set of people or towards others around you. But obviously there is a set of duty, or there are set of uh, precautions you have to take because of the rights of the other people around you as well. If you have your rights, the other person around you also has their rights. So because of this reason, there is a duty of care towards others, and if somebody breaches that duty of care, that is a case of negligence. So what we can say here is there are three requirements. First one is duty of care towards the plaintiff. Second one is that duty of care has actually been breached, and the third one is because of that breach, the plaintiff has suffered some damage. The best case law example is of Donog versus Stevenson. This case law is also called the ginger beer case. What happened in this case was that when the plaintiff bought a bottle of beer and opened it up, he found that a snail was in there inside the bottle in a dead condition. So obviously, if you have bought a bottle of beer, you won't actually consume that beer. And if you'll find a snail dead in it, that's not at all a good thing on the part of the customer. So in this case, it was held that the beer company is actually found responsible for this and was considered negligent, because ultimately they hold a duty of care towards their customers. They breached or they were found in a breach of that care, and ultimately they were considered, or they were called in for the compensation for this. So this is what the case of Donoghue versus Stevenson was, and this basically is what negligence is. So if you have a duty of care towards the other person and you have breached it, and the other person has suffered a loss because of that breach, you are to be considered under the act of negligence. You have to compensate for that. Now, let's talk about trespass. So trespass can be considered in two ways: trespass to land and trespass to person. So basically, trespass means that you have got on the, or you have encroached upon somebody's land or somebody's person. How can a trespass take place to a person? So there are two ways: battery and assault. Battery basically deals with the use of force against a person without unlawful justification. So always remember, in all the acts of tort, there is an essential requirement that there should not be a lawful justification for that. If there is a lawful justification, obviously it will not fall under the law of torts. So in every act of tort, there is an element that act should be without a lawful justification. So battery deals with the uses of force. What this uses can be: if we are slapping somebody, we are using a force on that other person, and that will actually cause a hurt to that other person. So this is basically a cause. This is basically a case of battery. So battery basically means the uses of force against a person without a lawful justification. Then what is assault? Assault is actually a reasonable apprehension of that battery. So if I have not slapped somebody, but yes, I have taken up my hand in a way that the other person has a reasonable apprehension that I will slap him. Or the best example is if I have shoot somebody with my pistol, that's battery. But if I am taking a pistol out and just pointing towards him, I have not shot it, or I have just made a air fire, then that will cause a threat in the mind of that person, or will cause a reasonable apprehension of battery in the minds of that person, and that will actually lead to the act of assault. So this is the difference between battery and assault. There is an actual hurt in the case of battery, where there is a fear of getting hurt in the case of assault. Now the third one, the trespass to land. This basically means that if I have a property, I have a land, and I have the rights over it. If somebody comes onto my land without my will or without my permission, that will lead to the trespass to land, which in the legal sense can be said that there is an interference with someone's possession of land without lawful justification. If I have consented to it, or if I have given the permission to it, it's a lawful justification to come upon to my land or to interfere with my possession. But if there is no such thing there, then it's an unlawful justification that why you have come here, why you have interfered with my possession of the land. So in that case, it will be considered a trespass to the land. Next one is defamation. Defamation, as we have all, I think all of us have heard this term. This basically means that causing injury to a person's reputation. So a reputation is always held in the eyes of a third person. You cannot hold a reputation for yourself, right? Even though we think of ourselves as like we are a very good person, we are doing very great, but that doesn't matter as far as defamation is concerned, because defamation is related to the injury that is caused to the person's reputation in the eyes of the third person, that is a society or anybody else apart from you and the person who is actually defaming you. So there can be two types of defamation: libel and slander. So libel basically means a defamation made or a statement made in order to defame somebody in a permanent form, like in printed form or in a telecasted or broadcasted form. Whereas slander is basically a statement of defamatory nature made in a non-permanent form, like verbally, if I am saying somebody is a thief. So that may be a case of slander. Now how that can be considered, that whether it is a particular case of defamation or not? So there are three requirements here. The first one is that the statement must be injurious to reputation. The very basic requirement is that that particular statement must be injurious to your reputation, that must damage your reputation in the eyes of the society or the third person. Second one is the plaintiff must be referred. So if I'm talking a general thing about a particular section, and you as a plaintiff is not specifically referred in that statement, that cannot be considered a defamation against you, because I'm not specifically referred you in my statement, right? So that is the second requirement, that the plaintiff must be referred. The third requirement is the statement must be published. What does the term publication here mean? So the publication doesn't actually mean to be printed per se. Publication or the word published here means that it must be, it must come to the knowledge of a third person other than you and the person who is defaming you. So if a statement, whether in the form of a libel or in slander, comes to the knowledge of a third person, only then it will be considered published, and then it will comprise all the three requirements of defamation. That is, the statement must be injurious to your reputation. The you or the plaintiff, which we are talking about here, must be referred in that statement, and that statement published or must be made known to third person. So if these three requirements are fulfilled, the defamation, the act of defamation or the tort of defamation is said to be committed. Now talking about the liabilities. So strict liability and absolute liability are two types of liabilities which are being imposed in case there are dangerous elements involved in a particular act which has caused the injury. So strict liability is imposed when a dangerous thing is brought on land with intention to be used for non-natural purpose and it escapes causing damage. So what basically strict liability means is that even though you are not specifically responsible for that damage, but since you have brought a dangerous thing on your land and that thing has escaped causing damage to others, you shall be strictly liable for that. But in case of strict liability, there are general defenses available. Best example here is of the case law Rellens versus Fletcher, in which there was a water reservoir made on a land for certain purposes, and then what happened, that reservoir overflowed or fell down, and all the water went outside of the land and damaged the coal mine. There was a coal mining facility nearby and went into that and damaged the entire property there. So in this case, it is not exactly the fault of the owner of that land who has made the water reservoir, but yes, they have done a certain act which was eminently dangerous. They have stored a large amount of water on their land, which if it escapes, it obviously will damage the surroundings, and because of that, uh, property that there was a damage to the nearby property or the coal mining facility, the owner of that particular land of water reservoir was considered strictly liable for this act. So strict liability, but yes, there are general defenses available. All the general defenses which we saw in the second slide of this session, these defenses are available in case of strict liability. But in India, a new concept emerged of absolute liability. So in strict liability, obviously, there are certain defenses available. In absolute liability, this is basically similar, or more or less similar to strict liability, but the only difference is that there is no defense available in this case. You are absolutely liable for the act that has caused the damage. So when will this apply, or when is this imposed? So absolute liability is imposed when a dangerous activity per se is carried out for profit. So in the first one, there is a dangerous thing which is not used for a very dangerous activity, but if it escapes and causes damage, strict liability will apply. In this case, the activity itself is dangerous. Like the best example here is, or the case in which this concept emerged was MC Mehta versus Union of India, in which there was a poisonous gas leak in Delhi, in a factory in Delhi. You can also relate this to the best example of Bhopal gas tragedy. So in these cases, the activity which was going on was including very dangerous or poisonous gases. So the activity per se was dangerous, and when these gases leaked, obviously we all know the result of that. It caused a lot of damage. So in these cases, absolute liability is imposed because you as the owner are actually carrying a dangerous activity, and you should take all the precautions available, and even if it is not your fault, still you will be considered liable for that within absolute liability. In the end, it's about vicarious liability. Vicarious liability basically means that it is the liability for the acts of another. Like in the previous two liabilities, absolute and strict liability, it was you were not held liable for the acts of another, but your own acts which were dangerous. But in vicarious liability, even if you have not done anything, even if you are not remotely related to the loss, but still you may be considered liable for that. Why? Because it is an exception to the general rule that a person is only liable for his own wrongful acts. This happens in these three important relationships. Within these three important relationships, these are master servant relationship, principal agent relationship, and partnerships. So what is master servant relationship? So if there is a three point test for this, that whether there is a master servant relationship or not. So for the acts of the servant, the master is vicariously liable. So when will that happen? So there is a hire and fire test. If the master is in a position to willingly hire and fire the other person, that is the servant, there is a master servant relationship. The second one is the direction and control test. If the master is in a position to direct and control the acts of the servant, then again this relationship will emerge and vicarious liability will be applicable. The third one is in the course of employment, that act for which we are talking about, that tort act, should take place within the course of employment. The servant himself or herself has his or her own life, so they may be doing xyz activities in their own life as well, but for those activities the master is not liable. The master is only liable for those activities which have been committed within the course of employment. And what does this course of employment means? That as per the directions of the master, if the servant is asked to do some act, to do something, and within the process of committing that act or doing that act, if the servant commits a tort act, then for that particular activity the master shall be held vicariously liable. Similarly, what is the principal agent relationship? So if on behalf of somebody, the other person is authorized to act. So an agent is a person who is actually authorized to act on behalf of somebody else, which is the principal in this case. And in the capacity of an agent, if he has committed something which comes under the law of torts, then the principal is actually vicariously liable for the act of the agent. Now the partnership is basically a situation where few of the people come together into a partnership agreement and are jointly liable for all the activities they commit. So for the act of a partner A, partner B can also be held liable under this vicarious liability. So this is basically what the types of liabilities are there, and this is actually an exception to the general rule. The general rule is that a person is only liable for his or her own wrongful act, but vicarious liability is actually an exception in these three cases: master servant, principal agent, and partnership. So what we have seen so far, I will just recap it here. Law of torts deals with twisted, wrong, or unlawful acts. It is based on the principle ubi just ibi remedium, which means for every wrongful act there must be some compensation. It includes two maxims: injuria sine damno, which means legal injury without actual damage, and damnum sine injuria, damage without legal injury, out of which law of torts applies only in the case of injuria sine damno and not damnum sine injuria, because there should be a legal injury, that is important, and actual damage, whether it is there or not, is not relevant as far as the purpose of law of torts is concerned. There are certain general defenses available: voluntary non-fit injuria, that is basically if you have voluntarily agreed to a risk of an injury, you cannot claim claim under law of torts for that. Plaintiff is the wrongdoer. If you are yourself the wrongdoer in a particular act of loss or injury, you cannot claim in that case as well. Inevitable accident, if there is something which cannot be avoided, if there is an accident which could not have been avoided, in that case also it will be a general defense. Act of God, obviously it is not within the control of the person, like natural calamities and all, it is considered to be an act of God. In that case also it's a general defense. In private defense, if somebody has committed a tortum act, that is again a defense in for the law of contracts. Mistake, if there is nobody at fault, obviously nobody can be considered responsible or liable under law of torts. Necessity, if there is a necessity, obviously certain acts need to be done for the sake of something good or something better, it is necessary, then that can be done under general defenses of law of torts. And statutory authority, if some act is authorized by them, then that act cannot be considered a tortum act for the sake of a claim under law of torts. For the sake of understanding these torts, there are certain essential acts of torts that we are going to do, that we have discussed today. Nuisance basically means unreasonable interference with a person's right over his property. It can be public, it can be private. Public is a part of the IPC, that is the criminal law, because it affects the society in general. Whereas private nuisance is something in which you or the person specifically has been a victim of that unreasonable interference over his right over his enjoyment of his property. Negligence basically means a breach of care towards others. There are three requirements. There is a duty of care towards the plaintiff. That duty of care has been breached. and the damage has occurred because of that breach. In that case, the act or the tort of negligence shall be invoked, and the person can claim under law of torts. Then there is trespass, trespass to person and trespass to land. Trespass to person constitutes battery and assault. Battery basically deals with the users of force against a person without lawful justification, and that actually causes a hurt. Whereas in assault, there is a reasonable apprehension of battery in the minds of the plaintiff. It's basically a fear of getting hurt. Trespass to land means to interfere with someone's possession of land without lawful justification. So this is basically what the tort of trespass are. Now the defamation. Defamation basically means causing injury to a person's reputation. This can be of two types, libel or slander. Libel basically means the defamation or the statement in a defamatory nature has been made in a permanent form, whereas in slander it's in a non-permanent form. The requirements are that the statement must be injurious to reputation, plaintiff must be referred in that statement, and that statement must be published. That basically means to be known to third person, not just the two of you, the plaintiff and the respondent, but the third person or the society in general. There are two types of liabilities, strict and absolute. Strict liability is imposed when a dangerous thing is brought on land with intention to be used for non-natural purposes and it escapes causing damage. So if a dangerous thing is being used by somebody for non-natural purposes and it escapes and causes damage, for that the person or the owner, even if not exactly responsible for that loss, shall be considered strictly liable, although there are general defenses available to him in this case. Whereas in absolute liability, there are no general defense, no defense actually available to the person, and this only is imposed when there is a dangerous activity per se that is being carried out for profit and that causes the harm. In the end, we have learned about vicarious liability. Vicarious liability is an exception to the general rule that a person is only liable for his or her own wrongful acts. Vicarious liability basically means liability for the acts of another. And this applies in the case of master-servant relationship, principal-agent relationship, and partnership. So this is basically what the basics of law of torts are. So you will get a full-on semester in your law college when you get into law colleges and learn about all these things in detail, and various other thoughts will be introduced to you. And there are a number of other thoughts as well. These are the important ones based on which generally the law entrance examinations ask questions on. So I have touched these are acts of thoughts for you guys, and I expect that maybe I was able to clear my case to you guys that this is basically, you at least you guys have got an idea of what law of torts is, what does it deal with, what types of torts can be there. You can just visualize, see, law of torts is not something that is documented, that's why there is no section here that we have to study about. These are basically based upon the common understanding and the development with the due process of time. So you can just visualize certain things around yourself, you can just think of things, think of such acts that are wrong, that are civil wrong for you, and maybe that act comes under law of torts. So you can think over it. You now have an idea how this law of torts is actually applicable, how does it apply to the masses in general. So based upon this, you may get certain questions in legal knowledge section where you can answer these questions based on the knowledge that I've shared. And also by after this class, obviously you will have to go through certain materials and you have to read about these things. If you don't have any material, you can read it on the internet. You can find it about law of torts, and there obviously you will be able to understand these concepts much easier now, because even if you have listened to me for this last half an hour or so, you will be in a position to understand what is there if you will read a material after this session. So I believe that sets up my case for today, that sets up the session for today, and this is the brief introduction to the law of torts. So yeah, thank you. If you have any question, you can ask me, or you can post it on the comment section, and maybe Samriddhi will let me know about the question.
Yeah, sir. So I personally had a question.
Yes.
Could you recommend us some sources from which the students could like get an idea of the law of torts in a more detailed way?
So what I generally suggest to all those students who ask me this question, what material should I refer, what not? I cannot, I have not found yet any very consolidated form of knowledge that can be considered sufficient. It all depends on the level of your preparation. So what I generally suggest is just have an idea of the syllabus of the law that you are going to read, like in this case, law of torts. So you know what you have to read about in law of torts for the purpose of preparation of law entrance examinations, and search about it on Google. You will definitely find some good articles. Read it. I don't suggest you guys to like find one particular document and just be stick towards it to it to the extent of that document itself. Then the amount of research you will do over it, the amount of material you will read about it, obviously that will increase your preparation and your chances of getting into a law college. This applies to every law. This applies to every section of law entrance. So what I generally suggest to everybody that just find out the syllabus, just find out what all is required for you to study within a particular syllabus, and then search about it on Google. Find few articles. Find, you will yourself come to know which article is actually good or not, because now you have a basic understanding of the concept. So after that, read those materials. There is no specific material that I would suggest, but yes, do some research over it. In this way, you will also inculcate a habit to look for things which you have no idea about. So that way it will help you in the longer run as well. So do this, and I suggest to read more and more. Read as much articles as you can over these topics. That will obviously be a bonus for you in the preparations.
So just one last question before we wrap up.
Yes.
So the CLAT examinations are coming in the next month. So what would be your Guru Gyan for the students that are appearing for CLAT this year?
Okay. See, the ultimate thing in the last few weeks or so before the preparation is to just cover up all the previous year questions. Just solve all these questions. It's, you should reach up to a situation where you already know the answer just by seeing the question. You should be in a position to understand. You don't have to waste your time on such questions which have already been asked in the previous years. You should just take out time for the new things that may be there in this year's examination. So what I suggest you guys is, even though the pattern has changed, even though new things will be there in this year, but still go through all the previous year questions, and not just CLAT. Try to find some other law entrance examinations as well. Maybe you will find something there, some pattern there which may be used this year in this year's examination. So as much as you can, try to cover the previous year questions from CLAT, from ELIT, from other law entrance examinations as well. And you should be in a position to just know how to solve a particular set or particular pattern of questions just by looking at it. You should reach up to this extent through your practice. In the last few weeks, this is the best thing that you can do.
Yes, sir. Yes, sir. Surely. And I would like, from the bottom of our heart, we would like to thank you for giving us such a wonderful session and making us understand the basic nuances of thoughts, and for the tips and tricks that you gave us. And I think this is Guru. You were one of the best people that we had for a Guru Samarth project,
Thank you.
and thank you so much for your time and patience, sir. Thank you so
Thank you
much.
so much. Thank you so much. And best wishes.